partner in the restructuring and insolvency practice. So my fellow panelists, can you hear me okay? Just checking in. Yeah, great. Okay, thank you. Very quickly, for those of you who are not as familiar with INSOL India, I'm hoping most of you are. It's an independent industry body. The idea of INSOL India is to bring together people and stakeholders who relate to restructuring, insolvency, and special situations. The industry's purpose, the industry body's purpose, is to promote discussions, to share experiences, to highlight industry issues, to ideate and promote solutions, and even represent before policymakers. For those of you who are not members, I would encourage you to look up our website and consider membership. We are discussing this evening a topic which is very current, which has had a lot of media attention, certainly before and even more so now. There are a few issues in terms of how people understand and interpret it. To help you navigate and think through some of the issues on this topic, we have a fantastic panel this evening, even if we say so ourselves. We have Santosh Shukla, who's an executive director with the Insolvency and Bankruptcy Board of India. He spent many years at SEBI before he's joined the industry policymaking and regulator institute. And Mr. Shukla has been now with the Insolvency and Bankruptcy Board for a little over 3 years. We also have with us Robert Korn from the Carlyle Aviation. He's a co-founder and president. He's been doing this for about 25 years. So fantastic to have you with us and give us a perspective of some of the lessons in this context. We have with us senior lawyer Vihan Vedkar at Lumia Law Partners, who's been doing this for a couple of decades and knows all the tricks of the trade in relation to the aviation sector. My friend Ashish Chavcharia, who has the restructuring team at Grant Thornton, he's been involved in the country's only aviation insolvency, so he's very familiar with all those issues. And last but certainly not the least, my friend Dhananjay Kumar, who leads the Mumbai restructuring team at a leading law firm, Sirila Machan Mangaldas, and has also worked on one of India's only insolvency processes. With that, I'll jump on to a few of the themes which I hope the panel will discuss. The idea, of course, is to discuss the interplay between the aircraft lessing arrangements and the moratorium under the IBC in the light of the recent 3rd October notification. In this context, what we expect the panel to discuss is, of course, who at the end of this process comes up, who's down, who's neutral, what are the gray issues in relation to the interpretation of this notification, what is the interaction of this change with the ongoing court processes, maybe a little bit about how, given the notification and the change, how would future airline insolvencies be resolved if post-insolvency lessors remove a lot of those aircraft basis this change? And indeed, how do other jurisdictions deal with this exact issue? Is there a moratorium? Is there not? Is there a modified approach? And lastly, if one is a resolution professional of an airline, which is an insolvency, is there any other means that they have to protect themselves or to retain some of the leases in the airline to maintain a going concern? Is there still some ability in the law sting in the tail? With that, I'm going to hand over to Dhananjay, who will moderate the session. Thank you, everyone.
Thank you, Nilang, and thank you for that kind introduction. As Nilang says, we have a lovely panel here, each expert in their own right. What we are going to talk about today is the relevance of this notification in the context of Capetown Convention, which India signed up to in sometime in 2008. And we have not had a full-fledged legislation implementing that. We have had some changes to the rules providing for deregistration and export type remedies. Specifically, there was no changes in relation to the insolvency proceedings, which became more relevant when the IBC came in. So that's what we want to discuss, as Nilang said, in much more detail. Just two housekeeping items. We have a Q&A box. Please don't use the chat box. Use the Q&A box for your question anytime during the session. If you would like to speak, please raise your hand and put it in the Q&A box that you would like to speak. And if we have the time, we would try to do that as well. And feel free to raise the question at any point during the session. So with that, I would go to my panelists. First, I would go to Mr. Shukla, who would tell us why this notification was required. What are the sort of policy reasons? What are the regulatory reasons to come out with this notification, and how does it help from an insolvency perspective? Mr. Shukla.
Thank you, and very good afternoon to all panelists and the viewers. And, thank you, DK, for introducing me. And this notification, as you know, that this has been a very pertinent discussion happening in the recent 7 to 8 months since beginning of May. But as you know, the code is very neutral about the sector-specific insolvency resolution. It is, of course, one of the objective is the balancing the stake of all stakeholders. And when we talk about all stakeholders, we cannot ignore the creditors and the lessors in such cases. So that is one thing, but predominantly the basic object is this rescuing the failing firm. So it becomes very, very predicament sort of situation, that how to protect the property in the hands of CD, at the same time how to allow that property to get out of the hands of the corporate debtor. So, but the policy makers have really a very catch-22 situations, I think. If you see the very objective of the Capetown Convention, it is not merely a commercial transaction, but it is also enhancing the international financial relationships. It of course protects and facilitates the international businesses, but definitely the Capetown Convention, if you see the provisions, it is also aiming at balancing the interest of the lessors to some extent. And as I understand that the government was facing a very, very precarious situation in the international trade and commerce in this area. Particularly, you know, the India was put on the watch list of the index with the possibility of degradation of India's score under the index on account of absence of secured legal regime governing protection of Capetown Convention lessors and the protocol. This was a major concern before the government. And other was the continuing without honoring the commitments of the international protocol that will also hamper the provisions of the financing because of the aviation assets substantially. Particularly, the borrowing cost of the aircraft would be increasing with unfavorable terms under the agreement. And as a consequence, what would be, there will be reduction of the supply of the aircraft, unfavorable terms, and Indian Airlines would be then adversely affected and it will affect the entire aviation industry. Other point which was in the minds of the government, being part of the deliberations to at some level, I can share, of course, that the cost of the higher lease rentals was also going to be passed on to the public, to the users, because they will be then paying the high fares on the all routes. And this will indirectly and directly again impact not only the aviation sector, but also on all sectors depending on the connectivity like tourism and cargo, etc. So these were the major policy concerns. Of course, the intersection between the Insolvency Code and the Capetown Convention, of course, was one of the reasons. But major concerns were the fallouts and the consequential conundrums that the governments were faced with. This notification, as you see, that it is trying to protect the lessors' right under the Capetown Convention, to honor the international commitments primarily, and also to protect the international business relationships, and then protecting the interest of the Indian stakeholders. To this extent, if you see that the objective of the code and the Capetown Conventions are somewhere converging, still leaving the intersection open, that in this sector, particularly the aviation sector, the way we are placed in, how to deal with it how to protect the investors, the lessors at the same time, protect the assets of the CD to keep it as a going concern, which I think is presently under the litigation, and the judiciary will be countering and coming out with some solutions on that. But this notification, be it prospective, retrospective, I don't know, the trades, future relationships, present relationship where the insolvency is not initiated. But if you see the Capetown Convention, the protection extent guaranteed too. If you see that they are allowed to within the wait period, within the wait period 2 months, I believe, that if the insolvency administrator is paying the current costs, current dues, then they can retain. Otherwise, after the expiry of the waiting period, they can take away the aircraft. But then the moratorium under 14(1)(d) and then 14(2)(a), which has the overriding effect over everything. That was the intersection. I think this notification is curing and correcting that intersection. So this precisely I can say about the reason why the notification has come in and what would be its impact on the international commerce and trades.
Thank you, Mr. Shukla. You are certainly right that this helps the lessors. I would say it also helps the creditors who may directly lend to an aviation company. And Ashish, if I can pull you in, how does it help the airlines? What benefit does it have for the airlines, and what impact will the aviation market feel now that we have this notification coming in and some clarity as to rights under CTC vis-a-vis IBC proceedings?
Thank you, Dhananjay, and very good afternoon to all the participants and my fellow panelists. Thank you, INSOL India, for this opportunity. Well, your question on how does it impact the airlines? I think first and foremost, we must consider that India acceded to this Capetown Convention somewhere back in 2008, right? And this is like 15 years in coming where this notification has passed. I leave it to the legal experts to comment on, whether this is today a law of the land or whether it needs some legislative, some further legislative steps. But simply as not a lawyer or not a legal expert in this arena, I can comment on the two aspects that you said. What does it mean for the airlines industry, the airline operator industry? I would say it depends on whose perspective you're looking at. From the current airline operators which are solvent, which are operating, I think it's a very important step because as Mr. Shukla was indicating earlier, the cost of not doing this would ultimately come down onto through the leasing, higher leasing cost, higher risk premium by the lessors would ultimately come down to the airline operating companies, and then depending on market demand and how much they could transfer on to the consumer. So I would say, given the recent news that we have been reading about the large orders being placed by the large airline operators like Indigo and Air India that we have all read about in the last 3-4 months, I think overall it's a very big positive for the sector. And if I look at it from a slightly larger perspective, for the country as a whole, this has an impact on keeping the costs in check. Aviation sector is a sunrise sector in the country. There's a huge potential, and we know the benefit of a vibrant aviation business in the country. So not only the costs could be somewhat contained to that extent, but also it has an impact on the foreign exchange balances of the country, because we know the majority of the lease expenses, or majority of the lessors are all coming from overseas, because that's where the capital is coming in from. And India is paying huge amount of foreign exchange outflow. So any percentage benefit on that is a benefit for the country's foreign exchange balances. So I would say that from that perspective, it's a great benefit. Now, what does it mean for the companies which are facing stress, which are facing challenges, we've seen Jet Airways, which went down, back in 2019, and more recently the Go Air case, and the whole issue around who has the right for possession of these aircrafts, who's going to maintain them, who's going to. One thing is very clear that maintenance of these aircrafts, preserving the value of these aircrafts, these assets is extremely important. And if a company is insolvent, company is not able to pay its dues, someone should be doing it, because otherwise they become quickly. I've learned that it very quickly becomes junk. So it's very important that it needs to be protected, because that's economic value in these assets. The companies, without having possession of these aircrafts, if it is clearly just taken away under the Capetown Convention rules, if it's taken away, then the chances of revival does get impacted. I personally had, I would have probably made a slight exception in this notification, and maybe I can share my views later on after some of the other panelists have also spoken on how to balance both the interests.
Sure, Ashish, I'll come back to you on that point, but let me take a lessor's perspective, since we have the benefit of having Robert on this panel. So Robert, a question to you is, before this notification, what has your experience been in the Indian market in terms of repossessing, exporting aircrafts out of India? And how do you think this will help lessors and players like yourselves?
Well, thank you very much, Sanjay. And good afternoon to everybody on the call. Carlyle Aviation's experience in India with relation to a bankruptcy really was the Jet Airways situation, which was very constructive for us, and the aircraft moved rather quickly into SpiceJet. So we didn't go through a process of trying to move aircraft out of the country. And I think that's a very good example of how a system could and should work. Our job as a financier is not to support failed businesses for the sake of employees finding jobs. I'd use the SpiceJet example with Jet Airways, where I dare say many, if not most, if not all employees in the aviation space have found new jobs in the space at other airlines in the area. Because what we need to step back and remember about aviation is that all of the reasons that people are hired and all the reasons that people are employed and seek to work there is because other people want to travel. So whether one airline goes out of business or another doesn't change the desire for travel. But the fact that an airline goes insolvent or has a bad financial situation is a reason someone would not want to travel with that airline, right? So if an artificial situation where an airline that's insolvent is continuing to hold assets and try to operate, that's something where, as you've seen in the existing discussions in current times, there's a strong concern that there could be a safety issue. So, I mean, our view is that what's happened and how this this law change will play out is to recreate a situation like we saw with Jet Airways, where there was a rapid movement of the assets to a productive place where they could continue to be operated and ultimately paid for. I don't know if that's helpful to you, but we're obviously strong believers of the the primacy of lessors' rights. I used to own Carlyle Aviation before my partner and I sold it to the Carlyle Group, but the aircraft are owned by investors. The aircraft are owned by ultimately the investors from pension funds, endowments, sovereign wealth funds that finance the acquisition and lease of these aircraft. And to the extent that those underlying investors don't have confidence in their ability to make a return, in the managers that manage their money to steward those assets wisely and safely, those assets won't be able to be put into the jurisdictions where people don't feel comfortable. And this is sort of a penultimate point about global aircraft leasing. and why rules like the Capetown Convention, which is now signed onto by 80 different countries, have come into law to create the ability for leasing to support the growth of airlines and airline activity to allow for travel globally. I mean, what we do and what we provide, I don't want to overstate, but it's a huge driver, our industry, to support the growth of low-cost travel around the world, which low-cost carriers, which are some of them are very successful. And when I say low cost, it doesn't mean low quality. It just means low cost. But a low-cost carrier, much of it is been the growth driver in Southeast Asia, where we've seen superstars such as Indigo and others outside of Asia, out of India, grow, have been very much supported by international lessors, supported by international capital, providing those assets and the investment in those assets. And when those parties don't feel comfortable that they can maintain control of their assets, that's when the capital flows. As you say, there's quite a bit more demand today than supply for these assets. And these assets will flow to other areas where the capital feels more confident that it can obtain its return and protect its assets.
Thank you, Robert. Those are very interesting points, and I may come back to you as a follow-up to some of those comments. But let's stay with the IBC for a minute, and if I can go back to Mr. Shukla. Mr. Shukla, do you see this as the next phase of evolution for the IBC? You spoke about is sector agnostic, but do we see any other similar industry-specific changes that are coming in or IBC requires for that matter?
See, I think the law is very nascent, as we know that only around 6 to 7 years we have seen the experience, but definitely the processes are throwing many challenges. And one such challenge is definitely the aviation sector, but and the government, you are all aware that before this notification came out, there was another notification about the petroleum and the gas, about the gas. So I think predominantly the national interest, I think, where is conflicting somewhere, the government is trying to balance the interest of the all stakeholders to some extent that way. But I think there would be needing, personally, I feel that there need to be some sort of sectoral dispensation need to be done. Like the court has also allowed the specific dispensation for the financial service providers. So same way, I think these things, I think, throwing the questions to the policymakers that perhaps there would be a thought to idea to give some sort of thought and discussion to bring out something very sector specific. For example, the fintech company, suppose they go in insolvency, perhaps the law is not very suitable for them. Like we are today facing a situation where we have to protect the property of the corporate debtor, and property, when you say the property includes the aviation, I mean aircrafts in this case. If you see section 14(1)(d), it talks about any property in the possession or occupation of the corporate debtor, very wide, not merely possession, even the occupation of the corporate debtor, that moratorium applies to that. So the law is very, very strict on that, that anything which is in the hands of the corporate debtor should remain in the hands of the corporate debtor. But in the aircraft sector, if you see, that is not working. So definitely we need to think on those lines somewhere. But in this case, I think, as I said, apart from the balancing the interest of the lessor, there was also a thought behind availability of the credit, as Ashish mentioned, that we will be losing the business somewhere. The cost of borrowing would be very, very high. So there's also, I think, was a thought idea behind this notification. I believe that there would be need to go for this sector specific dispensation.
Thank you, sir. And I intend to investigate with Ashish further. How does it affect the going concern status? So Ashish, how does it help the resolution? Will going concern status will be affected? And we already have two questions on this issue. One specifically on this, that if the aircrafts are taken away, how do you keep the company as a going concern? And secondly, of course, this notification does not apply to slots. So without the slots, how does the company remain going concern? How do you resolve the company?
Very good questions, and it's a moot point, and we have dealt with both these issues at length during my experience in Jet Airways. If I first talk about the aircrafts and the moratorium or the lack of it, on the aircraft assets, certainly aircrafts are a very key asset of the business, right? It's a very key operating asset of the business, whether it's owned or it's leased. And without aircrafts, what is an airline operator going to do? So yes, it does affect the going concern status of the company, in my view. Having said that, it will affect the going concern of a company if it is actually it is a going concern. So I think if a company or an operator is unable to operate those assets due to working capital constraints or not having been able to pay its employees, oil companies, etc., and if it is lying, sitting on the tarmac, it doesn't really help anyone. And that brings me to the point which I was going to make earlier, that what exception would I have liked to see in this? And that is, if a company is still operating, it's not grounded, the fact that it's insolvent or solvent is a cash flow test. It may be that out of 45 aircrafts, it is able to operate 10 aircrafts to keep the engine moving, to keep the company going, be able to operate in a scaled down manner. Those aircrafts which are still being operated and for which the company is able to pay its lease charges, I think that those should have been kept out of this notification. In other words, the company should have the right to continue to see if it can, revive. And this is completely my personal view, because if there is a right to remove all the aircrafts, whether operating, not operating, and just because on a cash flow test basis, the company became insolvent for a period of time, then the chances of revival become that much lesser, right? So as a resolution professional, I would say that this additional test probably would have been helpful in this, that is the company able to utilize and pay for them on an ongoing basis? Else, there's no reason why it should be held, and there should be reasonable period of time for allowing that test, maybe 60 days, 90 days, something like that. Coming to the point of slots, I think this has been an issue of big debate during Jet Airways litigations as well. I think slots is not a tradable commodity. It's not something which is bought and sold, at least in India it is not. And it is currently allocated by the Slot Coordination Committee. And there are a few constrained airports where this is a challenge. All the airline, regulators, the ministry, we always got that assurance that slots for the company would be retained for a foreseeable period of time, right? But it cannot be at the cost of, again, impacting the people, because we know how the airfares had shot up when, there were no airlines being operated in those particular peak time slots. So they were temporarily given out to other airlines. Now, that temporary means how long, right? It cannot be indefinite. So if we again look at Jet Airways example, it's now been 4 years or more since it's been grounded. Now, if under moratorium, these would have been kept ring-fenced, I think that would have really impacted the industry, right? So yes, there should be a reasonable protection, because slots, as like aircrafts, probably even more important to retain those rights, but cannot be indefinite. That would be my submission.
Sure, thank you.
Back to you, Dhananjay.
I would just add one thing to what you said. I think what the points you made are valid. One thing I would say is, one possible way to deal with this, and that's possibly that was the intent of having IBC in place anyway, is to have early detection of stress. If you look at many international restructurings and insolvencies, the restructuring discussions start looking at the horizon of upcoming payments and whether those will be missed. So if this notification is in place and these rights are strengthened, possibly airlines will be forced to start into and enter into these discussions prior to defaults occurring. So that might actually be helpful for the industry as well. So what I'm trying to say is maybe you wouldn't have to worry about a going concern status being affected in a full-fledged formal insolvency. Maybe it will spur the players to start restructuring discussion even prior to defaults. So that was one thing that I wanted to add. But coming to Vihang, and since he's the only other lawyer, I'm saving all the difficult questions for him. So Vihang, my question to you is, what is the effect or applicability of this notification to ongoing insolvency proceedings?
Yeah, hi. Good evening, everyone, and thanks, Dhananjay, Nilang, and INSOL, and the rest of the panelists. So I'll quickly try and summarize my views on what the impact is on the current proceedings. So the current proceedings, I don't think there'll be an immediate impact, at least as of things the way they stand today. It hasn't affected anything, though the notification has been issued some time ago, I mean, a week ago. The proceedings before the Delhi High Court are largely, the predominant question is whether the moratorium would apply when a lease agreement for an aircraft has been terminated, but the agreement for the aircraft is still in the possession of the corporate debtor when the moratorium commences. In that situation, does the moratorium apply or doesn't apply? And that's the question. So while the notification is not directly challenged in these proceedings, it's no doubt that it'll have a bearing on how these proceedings will go ahead and how the High Court and the NCLT will look at the issue as they go along. So they will have to, in my view, in the coming weeks, form a view on whether it is retrospectively applicable to the Go First issue, whether it's not retrospectively applicable, whether it'll be applicable only to future insolvencies, or whether it'll be some interim way to handle it. So it's, at least to me, as a lawyer, reading the notification, hearing various views, I'm still not clear on whether it applies retrospectively to an existing moratorium, especially when in this case there is a order from the NCLT which allows the airline to resume operations with the aircraft that it has in its possession, despite the termination. A notification clearly nullifies that order, right? And whether that was the intention, we don't know. Maybe it was issued to address this issue. Whether it does completely address this issue, I think is the jury is still out on that, and I think the court will soon form a view. But at least as of now, I don't see any impact, because the notification will have no impact unless the DGCA actually acts on the notification. And from what I understand, the DGCA is unlikely to act on this unless they receive directions from the High Court in respect of that. So currently, the position of the DGCA seems to be that we need clarification on our own proactively, and we are not going to start deregistering aircraft based on this notification. So currently, I think it's wait and watch, and of course, given the potential impact, we'll have to see how the High Court will decide in this matter. Whichever way it decides, given the sort of fact that several people are involved, I'm sure it will be carried in appeal. So while the notification will help for sure lessors in future insolvencies that may or may not happen, at least as of now, I don't see any immediate impact on account of the notification. So that's my brief comment. I think the current proceedings will continue for a while unless the High Court hears everyone, forms a view, and says specifically that the notification will apply from, or will, the moratorium has been lifted in respect of Goer's assets for the for the existing proceedings. Only then will DGC actually act upon it. But till then, I think it will just be status quo.
Thank you. I know I sort of agree with you. However, I was thinking about it slightly differently. I was thinking about it, if I remove the sort of whole High Court angle for a minute, there have been several amendments to the IBC, including, say, big ones like 29A, and those applied to ongoing proceedings which were in the middle of CIRP. So if nothing else, it should apply from October 3rd. And if the lessors and as I said, I'm keeping the High Court issue aside. If nothing else, from October 3rd, the rights and the exemptions from the moratorium should become applicable. So that was one way to think about it. And I agree with you that the High Court and possibly even the NCLT will need to get into it. And we all know that there have been few of these cases. And so how it will play out is to be seen in context of ongoing proceedings. So that was, but I will stay on the sort of legal interpretation of this for a minute. And that was another question that was received, that if you look at the sort of the fine print of the notification, it relates only to 14.1 of the moratorium, whereas in 14.2 capital A, there is a right of the resolution professional to designate certain contracts and supply of goods and services as essential to going concern status, and those cannot be terminated unless there is a payment default. That came in. Now, one could say that this notification, not one could, this does not refer to 14.2A, it only refers to 14.1. So how do you reconcile this situation? Can an RP, and as someone like Ashish was saying, that you will have to try to save it at some point, can you use this to say that all my aircraft leases are actually essential for going concern under 14.2A, and therefore this exemption does not even apply? I'm sorry, I just noticed Robert has dropped off, but we will continue. I'm hoping he will join soon.
Sure. So I think, obviously there is scope for argument that ideally the notification should have been clear in terms of whether 14.2 is also, or will it apply to 14.2 as well? And 14.2, of course, is relevant for a situation where the corporate debtor is going to continue operations or is trying to resume operations, and those operations or the continuation of those operations shouldn't be interrupted on account of other essentials that are being provided to it. So there is some guidance in the regulations or in the rules in terms of what essential services would entail. And I think essential services are largely services like provision of water, provision of electricity, telecommunication services, IT services, but not really any services that are a direct input to the output produced by the corporate debtor. And given that airlines are not really just peripheral services, but the aircraft is intrinsic to the delivery of the product or the services by the aircraft, so the airline. I think it'll be difficult to say or difficult to sustain an argument saying that the aircraft are actually essential or should be qualified or should be within the garb of essential services to an aircraft. So I think it's while there is still scope for argument, I would be quite surprised if the definition of essential services is actually extended to airline.
Yeah, I think that's helpful. And I was thinking about this issue as well. And another answer that I could think of is the remedy of repossession in relation to lessor is specific to 14.1. And therefore an argument, can exist that 14.2 is more a general provision, whereas a remedy to repossession for a lessor is actually specifically covered in 14.1. And therefore, if one were to say this exemption applies, it is 14.1 which was prohibiting a lessor and not 14.2A. So that was another way. But as everyone says, time will tell what happens to this issue.
Dhananjay, sorry, if I may just add a comment to this discussion.
Sure.
You see, there's also a small exception provided in the 14.2A as well, right? Where it says that where such a corporate debtor has not paid dues arising for such supply during the moratorium period, right? So what my understanding of what it means is that if the corporate debtor is able to continue paying for it during this CIRP period, then possibly that would apply, right? The essential services definition is assuming that essential services could cover this. And that brings back to my point, what I made earlier, that if a company is able to pay for it during the CIRP process, then maybe this exception should be there. But if the company is not able to pay, just by possessing or holding on to the asset, is ultimately, destroying value, and also from a, maintenance and preservation of asset perspective. So that's the point I wanted to make in 14.2a.
Sure. Thanks, Ashish. And I can see Robert is back online. And Robert, I next question was for you, so very timely for you to log back in. Do you see this development as helping the level of rentals? Will they come down? Will you negotiate differently the terms of a lease that next time you enter into India? Can you talk a little bit about that?
But I think it's to be seen. I think what's happening is, I think lessors had taken the view that the Jet Airways example, as opposed to the Kingfisher example, was what the new norm was in India. So I think the Go First activities have been a huge international black mark on India for the finance community. And I believe it's resulted in certain airlines having lessors that had proposed to put equipment into them to remove those proposals. And that then gets into a simple supply of money and demand for aircraft equation inside of India, as well as on a macro basis, the risk adjustment for India will go up, and therefore aircraft will flow other places. So to get them back, it's going to result in having to pay more or do certain things to make lessors comfortable. I don't want to say on a micro basis it's going to affect every individual lessor the same way or every airline the same, but certainly for a small airline that's more at risk, a lessor is going to have to think quite a bit harder before they make the investment in aircraft in that airline, which could result in the strong get stronger and the weak get weaker, which could result in less airlines and therefore less competition, which goes back to the first conversation, which all this cost is going to end up being passed forward to the consumer, right? And I understand that a significant concern has been jobs and loss of jobs. I personally believe that's not a well thought through environment, where I look at what is happening in the background at Go First, where other airlines would love nothing more than to get that equipment. Well, by getting that equipment, they need to get qualified Indian staff to operate that equipment. And therefore, if properly thought through, it should be a situation where an airline that goes out of business in India should simply, the equipment should be able to stay and the people retain employment. But like you guys have been doing this for a long time, and some of you are restructuring professionals. So you would think that if a business was in bad shape economically, long before it had to file bankruptcy, it would be looking for new investors and new stakeholders. If it's unable to find those new investors and new stakeholders prior to go bankruptcy, it's either because the prior owner has misjudged the situation, or it's simply an airline or a business that is not set up to operate in a competitive environment. And many years ago, the airline business was not a competitive environment. It was regulated by the governments, and it was a public service. And I think many times we need to remember that governments have migrated this business primarily to a public market where supply and demand and need to let that activity occur naturally. And if there's no way for an airline to make money or a business to make money, either it should be sold to somebody who can do that, or it should simply stop existing.
Well, thanks, Arun.
So I mean that's my view. I don't know if that's helpful to the audience.
No, it's certainly helpful. Thank you. I'm going to change track slightly, and I'll go to Vihang, and I'm going to come back to you, Robert, on this question as well. There have been some talk of Gift City being an aircraft leasing destination. We have seen early shoots of that. We have seen some success on that with the sort of the recent transactions. But do you think this is the impetus it needed? This is the push that will help Gift City become a leasing destination? And Robert, the same question to you once Vihang finishes.
Thanks, Dhananjay. So I think, you're right. I mean, Gift City is an excellent, option for several international lessors to use India or Gift City as a base to sort of lease aircraft through. But, I'm not sure whether that the perception of the Gift City being a fantastic place to do business in vis-a-vis India is going to be largely affected by this notification. So I think the perception is not going to change on account of this notification. Of course, if there's a Cape Town Convention bill, there is a situation where the Cape Town is fully implemented into India rather than an interim solution like a notification. Then of course I think the Gift City will do extremely well. So under the Cape Town Convention, there are certain transactions which are known as internal transactions. Those are so effectively if the transaction is in relation to an aircraft within a country and the essential parties to that transaction are also within the same country, then Cape Town Convention gave the signatories of various countries the option to exclude those transactions from the Cape Town Convention. India, of course, consciously opted not to exclude its internal transactions. So while a transaction from a Cape Town Convention lessor to an Indian operator would qualify as an internal transaction, India has consciously decided that we will still allocate the same level of benefit that we would do to a foreign lessor under the Cape Town Convention, whether it's priority, whether it's the IDERA, whether it's international registration. So all those benefits will also be applicable to someone who's in the Gift City. So we won't treat that as a separate transaction, but we'll give the benefits that Cape Town otherwise would have accorded. So I think, also there's the Cape Town Convention bill, which was circulated for public comments about a year ago. Even there, India made its intention clear that it intends for that bill to also cover internal transactions, so long as they're not inconsistent with domestic laws. So given that that's the case, I think lessors are going to be just as benefited whether they're in the Gift City or otherwise. But the fact that India is moving towards a Cape Town implemented regime will certainly, I think, give impetus to the Gift City being a more and more attractive place. And, lessors will now warm up to using Gift City as an option for leasing into India. So I think this is certainly a step in the right direction. I don't think it's sufficient, but it will certainly help or go a long way in building the reputation of the Gift City.
Robert, your comments on this?
I think it's to be seen for us, to be very candid. There's certainly, as I understand, like with finance leases, there's a different tax treatment of the lending party, and there's a strong benefit or need to have a entity within India in certain structures. I think what we're looking for is the most cost-efficient structure that gives us the most protection to provide leasing solutions to our customers. If the Gift City structure is simply a pass-through that creates more cost, regrettably, that's just simply passed through to the airline. Now, I understand very clearly why jurisdictions are trying to create core technology and create industries that employ people and create jobs. So if Gift City ultimately becomes a leasing hub that is a true place for lessors to operate from rather than just a tax pass-through, and there's various examples of each, some of which are very healthy and constructive, and there's others that are just simply pass-throughs. So this is very, very early times for India. India is a very, very large market that's only going to get bigger. So and there's an amazing pool of talent resides in and comes from India that many, if not all of the lessors, including ourselves, tap and hire, and are very proud of those Indian employees. So to the extent that there is a true hub of leasing activity based in India, then this is a great opportunity for the industry.
Thank you, Robert. Let me go back to Mr. Shukla. We have heard two, I would say, legal concerns. One is on the sort of retrospectivity, and second on how it plays out with 14.2a. Do you think a clarification is required on these aspects, or how would you think the players should react to this?
See, this is a question I think presently, I believe it is before the tribunal also. The adjudicating authority has also, I think, the notification is in place before them for interpretation, and they have given some date on 19th of October, I believe. Because the NCLAT has referred this matter back to them to reconsider that. So, of course, there are doubts. I can't deny that there are doubts about the prospectivity. As we see, there is no mentioning of section 14.2a. But as we discussed that, it is my again personal view that 14.1 is the genesis of the moratorium, 14.1d particularly. If you take out 14.1d from the clutches of the moratorium, then 14.2a remains a very, very minuscule thing to operate. I think, again, the language will be interpreted by the courts. What would mean by the supply of the goods or services, whether they already handed over the aircrafts will remain to be a supply of the goods. I mean, those things are to be interpreted, but I think some clarification, perhaps from the judicial interpretations. I am not sure whether any administrative intervention would be coming out, but definitely the judiciary is encountering these questions, and some sort of clarity would come out. High Court is also possessing, I think, seized up this issue, because this issue again is being raised before the High Court also. I believe so. I have not seen the petitions. I think IBBI is nowhere in the party, but I think this issue definitely will be raised before the High Court also in the writ jurisdiction. Hopefully some clarity will come, but I think this is really throwing out the debate. Judiciary is leaving the questions open, then perhaps legislature has to do something, because this pro tem arrangement of notification, as we all understood today, is not going to help in the long run. Some sort of basic and very comprehensive framework need to be thought of. Another issue which I am raising here, of course, we are discussing, but away from the topic, but because this notification is under the IBC, what will happen to a liquidation of the Companies Act? So that still will be requiring a debate. So I think this debate has generated, definitely we will find some solutions to it.
Yes, I think that's very thoughtful comment, Mr. Shukla. Now let me change track slightly again and go to Ashish, who was very concerned about how do you rescue a company with this. So Ashish, what challenges do you see an RP of an airline company facing now? For example, will the costs go up substantially, since you will have to effectively pay, and that's the option India has picked? You will have to pay the aircraft leases during insolvency so that you can continue. So do you see costs going up? Do you see any other challenges in respect of an RP running a CIRP of an airline company?
Well, I certainly hope there are not too many of these, because under IBC, in its current framework, the way it is, resolving an airline is proving quite challenging, as we have seen in these two instances. Though I must say, in Jet Airways, we have a resolution, and hopefully, it will fly again soon. But the extent of time and the challenges are many, right? Due to slots and aircrafts and so on and so forth. As far as your question on cost is concerned, I don't particularly see this resulting in any additional cost, because in any case, whether you pay for it right away or not, it is a priority cost. It's a CIRP cost if you are using any of the assets during CIRP process, whether it's a leased asset or any services that you enjoy. So overall, it's a cash flow perspective, but cash cost-wise, I don't think this would have an impact. On your question regarding, how does it impact the resolution? I mean, certainly, as we discussed, that slots and aircrafts, and of course, employees, people, trained manpower, these are the three key elements, right, for airline operator. And in the absence of aircrafts, it would be very difficult to, revive the business. So it is something, a modified approach, probably, would be better if in case we want to revive an airline under the insolvency code, But I think, as was being mentioned by some of the other panelists before me as well, that if an airline is headed towards insolvency, I think it is trying to find a solution prior to official filing. Something like a prepack is probably probably a better solution. I'm not referring to prepack in its current form as it is in the IBC, but prepack in general, to try and sort of restructure, find new investors, find partners for the business, and see that doesn't get grounded. There may be scaled down operations, but doesn't get fully grounded, because to the best of my knowledge, it's never been that airline which has been grounded has able to take off again in its own avatar. So that would be my thoughts on this, that try and protect before, save it from going into a proper insolvency in its current framework under IBC, the way it stands now. So otherwise it becomes extremely difficult for revival.
Yeah, no, I agree with you. And this sort of goes back to one of the points that I was making earlier. I think it encourages early detection and resolution of financial difficulties. And airline companies may have to think of solutions well before defaults start happening and repossessions and IDRs start getting filed. So no, certainly that is in order after the notification has come. Robert, if I can come to you, since you have wide expertise and experience in various jurisdictions, how does India now compare with, you can take any two other jurisdiction in respect of aircraft leasing? Would you say, we are now at par in terms of legal regime, or do you think something else is needed?
Well, I think there's really a strong question about if this, and I think the resolution professional in the Go First case still continues to pursue his case that this is not applicable to that situation. So I think there's still a small piece of how this law applies in real practice to be seen. I think it's certainly moving in the right direction, and I'm very pleased with it. It certainly will help us with our ability to source funding, we hope, and at a better price, which makes us more competitive, right? So, but I still think it's to be seen, right? And I like Ashish's comment about a prepack and organizing something, because while in form, and I go back to what I just said about practice, in form, that's the idea, is that these costs of leasing are a cash flow issue and they simply accumulate. In practice, I think the next potential buyer that comes in has a very different view, and the way the bankruptcy law is drafted and the way the situation is occurring creates a situation where a new acquirer of an airline comes in and says, hey, look, guys that have airplanes here, I'm happy to fly them, but I'm not paying for the past, or I'll pay pennies on the dollar. But I can tell you, and I address this comment to anybody that's a lawmaker, the way the situation is currently playing out is not, especially in certain the historical ones, and certainly with Go First, I don't want to use the word, but we're trapped, right? We're trapped. And the first time it happens to you, it's not your fault, but you can be sure you're going to be wise the second time and not let it happen again. And so a situation like Go First, where all the lessors want to leave and a resolution professional that has no funding is forcing us to stay, doesn't create a healthy environment for wanting to try that again. I would encourage, if there's truly a qualified buyer that wants to buy it, rather than just, reports that this guy's interested or not, that party should have showed up by now and be willing, as you said, to pay the past dues, right? Rather than the resolution professional trying to keep the airplanes and negotiate with a what if and what if, right? Maybe I'm getting into specifics, but I don't think this is a healthy situation for India. The continuation of this situation is only at the expense of Indigo and Air India and SpiceJet and Akasa. It's really at the expense of the healthy airlines that are trying to provide service to the Indian public that we let the situation continue in a way that there hasn't been a true solution come forward. And I think that's what Capetown really does, which says if you have 60 days to solve it, as I think somebody here early said, allow 60 to 90 days to solve it. But if an airline can't get up and flying and start paying its bills and set a course in a reasonable amount of time, at some point we have to call a spade a spade.
Sure, thank you. Why don't we take some questions now? We had a couple of them, and then we'll come back for closing comments. So the first one, I think it can go to Mr. Shukla, which is the question is, what is the viability of setting up a social impact fund, which is to be earmarked for financing distressed airlines during CIRP, something similar to what was done for real estate sector in 2019?
Good thought, I would say. I think nothing wrong in wishing and thinking down those lines, but I would be really, I think it is not a so good question to me. I think this question could be passed on to the government. Of course, definitely, I will pass it on to the government. But the answer from me would be just diplomatic, that it is wishful thinking and a good thought to ponder upon.
Thank you, sir. Next one, between Ashish and Vihang, the question is, what is the key difference between an airport developer or operator insolvency and airline insolvency? Can the former lead to the latter as a domino effect?
Vihang, you want to go first?
Sure. I mean, I think the airport business and the airline business are, while they're in the same sector, they're completely different in that sense. The airline business depends on assets, at least in the Indian and the region, on assets which it doesn't own and which are not on its balance sheet in many cases. Of course, in financial leases, they could be on the balance sheet, but they're not assets owned by the airline. And that's what makes it trickier in a situation where the assets are owned by someone else, but are sort of critical for the survival of the corporate debtor. So I think an airline insolvency, and I completely agree with some of the other panelists, that in relation to an airline insolvency, you need a regime that is slightly different in certain situations than a standard insolvency of a manufacturing entity or an infra company or a services company, because there are nuances here, like in the real estate space, like someone else has pointed out. There are nuances here which need to be catered to separately, and the ends of justice will be met not by putting everyone in the same straitjacket formula of Section 14, moratorium, but having to, at least for some industries like the airline industry, finding a different solution. And sort of an airport developer, I think, doesn't fall in that category. So I think it's completely different. Also, I don't think the fact that an airport or an airport operator goes into liquidation, winding up, or resolution process could have a domino effect on an airline. I think they're completely different. So that's my view, Ashish. I mean, you can supplement.
No, I completely agree that it's very different. Very different. Though both in the aviation sector, I think the business model, the operating model is completely different. I would call this the airport operators more in the akin to a real estate play, a commercial real estate play, than really so much of aviation. Yes, of course, I mean, a very integral part, but I don't think they would have a direct impact on this if it is resolved quickly. The former insolvency, if there's an insolvency in the airport operator side. I know there have been instances in India as well in the past where there have been questions on the solvency of some large airport operators, but thankfully, they have changed hands. There have been privatizations. So I think they would be unrelated. I don't think it would directly impact, especially not in the short term.
Sure. And the last question we had on, do we need a separate framework for aviation sector? For example, some of the judicial innovations such as project-wise CIRP, reverse CIRP, do we need anything specific? So whoever wants to take this. Ashish, since you have a lot of experience in this.
I think
Yes,
Mr.
DK,
Shukla,
just
please.
just a brief comment.
Yes.
Just a brief comment on this. I think we have broadly covered this question.
Yes.
But see, innovation is there in the code. I think the code, it is my personal view again. I think the market and the that is very restrictive, but I think code is very, very flexible. And of course, if there is doubt coming on, the law can come in, but I think the code has given enough opportunity for innovations. And reverse CIRP or project-wise CIRP, in my personal view, they are inbuilt in the code. That is not out of the code as the question is being pointing out. And definitely, in my personal view, and again, I think that many of you agree with me, there is a need for a special dispensation because the aviation sector is not fitting in the one-size-fits-all formula of present framework which the tribunals and we are working in. Within the framework, we need to carve out certain things as this notification is seeking to do it. Of course, leaving a lot of room for interpretation, but I think a good move, I would say, in this, in the interest of international business. But there is a need, I personally feel. So, Ashish, you can take on further things. Thank you so much.
Thank you, sir. Thank you. I think I alluded to that earlier as well, that in its current form, the IBC, the way the provisions are probably not best suited for the aviation sector. And I think this is a step in the right direction. More focus or more, early detection, pre-insolvency or a prepack kind of thing probably would result in better outcome, at least from the experience of these two that we have seen so far. So yes, but what that shape and form will be, I think, will need to evolve. We also have the benefit of having Nilang here. I'm going to put him on a spot. He's also, been involved in airlines on solvency quite a bit. So if you have any different views or if you have some views to share on this.
Thanks, Ashish. You always manage to catch me when I'm not prepared. But no, Ashish, I think I agree with you and I agree to what you were saying earlier. I do think this size certainly does not fit airlines. Maybe it doesn't fit service industries more generally. And that's an issue not only in India, it's an issue more generally across jurisdictions. I don't know if the prepack will be the answer, but for now, I think it may be the only solution. Really to resolve, and a company whose value is not in its assets, but in its services, and whose services rely on various stakeholders staying together despite an insolvency or despite distress. So hopefully, I think, there are talks already of prepack being extended to larger corporates later this year. Hopefully that does happen, and hopefully we see a change in the manner in which we resolve service companies.
Okay. So I have no further questions to ask specifically, but happy for anyone to make any closing remarks. Mr. Shukla, would you like to make any closing remarks first?
Oh, thank you. Pardon me, I think there is some network issue at my end, but hopefully I will finish it fast. Firstly, I think this is really good discussion and very good ideas have come out of it. But I think in this sector, I think visibility is quite more than any other sector. I personally feel that visibility of the default. If the businesses can foresee the default early and detect it early and try to take corrective measures, perhaps that could be a better solution. I would go by what Ashish says, not really in the present framework of the prepack. Perhaps it will further damage the insolvency of the service sector if you go in the present prepack system. But definitely what code is futuristically contemplating by amendment, what we are calling about the creditor-led resolution, something like that. Perhaps that around that something could be perhaps be worked out. I think that could be a possible way of resolving these service sectors. Present setup, personally, in my personal view, is not very suitable to it.
Robert, Ashish, Vihang, any closing comments from you?
We as a firm are very interested in being a strong, large participant in the business in India, and anything that can be done to help us in doing that is really beneficial, and it'll result in real benefits to ultimately the Indian traveling public.
Ashish, you want to go next?
No, nothing further from my side. I think I've said.
Vihang?
So I think just, sorry, go ahead, Ashish, you were saying something.
No, I was gonna after closing comments, maybe I was gonna ask you that this interim you mentioned about this interim step of a notification,
yeah,
vis-a-vis the full bill. What would be the difference? What's the impact? What were you trying to say?
So the Cape Town Convention is not just about having the ability to repossess in the case of an IBC. It's a very wide protocol and a convention which deals with several issues, right? How to accord priority, how to deal with interests other than the ones that are recorded, etc., etc. It's important, I think, to have a full, the Cape Town Convention bill implemented in India in a manner that suits India, not just a carte blanche saying that Cape Town Convention overrides all Indian laws, because that doesn't achieve the purpose. The moment it can be interweaved into law into India and absorbed in the right spirit, takes care of the lessors and the financing committee, but also at the same time takes care of employees, tax authorities, airport operators, fuel suppliers. You have other suppliers, you have other lessors other than aircraft lessors like small parts, APU suppliers, those kind of. So long as there is a holistic solution, and I think the Cape Town Convention actually offers that holistic solution. The notification is just one small step in the right direction, but it's like an interim step. It doesn't cover all the other concerns that lessors want. Most lessors, Ashish, I was saying, most lessors want certainty. So long as you have not just one notification, not just one abrupt standard operating process issued to address the jet kind of situation, as in 2018. So long as there is a comprehensive solution, I think the amount of confidence in the Indian market will be substantially higher. So that, I think, is my view.
No, thanks for that. Actually, I gathered that the Cape Town Convention, of course, is a much larger suite of provisions there. But I thought, with respect to this particular aspect of repossession, is there any material difference in that? But I guess it is dependent on various other factors. Fine, we can take it offline.
So maybe I can just spend a minute more. There is a difference in the Cape Town Convention. As someone already mentioned, there is in the event of a potential liquidation or insolvency resolution process, the RP has the ability to keep the aircraft and the assets and try for 60 days before it has to hand it over to the lessor, right? So it has this arrangement of 60 days. This notification, unfortunately, does away with those 60 days. So I don't think it's it's consistent with the Cape Town Convention. I think it needs to be reconciled with that.
Yeah, and I agree with Vihang. Certainly the bill implementing the entire Cape Town Convention has been in works for some time, and I'm hoping this will come in soon to deal with some of these issues, including what Mr. Shukla was talking about in terms of liquidation under Companies Act. That will also get covered. But that's all the time we have today. And for the last word, Nilang.
Thank you, Dhananjay. I hope you give me more such opportunities to put in the last word. Listen, thank you everyone for joining us. Dhananjay, thank you. That was wonderfully moderated. Thank you, panelists, for joining. Thank you, Mr. Shukla, for joining us and for being so clear and candid. Thank you, Robert, for waking up so early in Miami and joining us all the way from there. Thank you, Ashish and Vihang. Very quickly, I should say, what I've taken away from here is clearly this is a step in the right direction for lessors, the aviation industry, for the healthy airlines. For the not so healthy airlines, it's a bit of a wait and watch and see how we get them resolved under the current law, under revised laws. Also, a little bit of a wait and watch in terms of more developments in this particular point, in terms of how courts interpret this, in terms of how regulators interpret this. So it's going to be an interesting space to watch, and maybe we're going to get back together in 6 months and reevaluate our discussions. And look forward to seeing all of you there. Thank you, Dinkar, our INSOL new president, for driving us and for giving us the push to hold these webinars. And I think for all the participants out there, wait and look out for many more such webinars and events from INSOL India. If you want to write in, please do write in at contact@insolindia.com, and please follow us on LinkedIn for more events and news in relation to restructuring, insolvency, and special sits. Thank you. Good evening, everyone, and have a lovely weekend. Cheers. Bye-bye.
Thank you, Tilan.
Thank you.
Thanks, everyone.
Thank you.
Thanks, everyone.